Imagine you just found your absolute dream house.
Oh, okay, I'm picturing it.
Right. So you do the walkthrough, you fall in love with the place, you shake hands with the seller, and you wire over your entire life savings.
Which is terrifying, but yeah, that is how it works.
Yeah, you get the keys. But then the very next morning, that exact same seller drags you into court
Wait, the next morning?
the next morning. And he tells the judge that he has a confession. He says that when he sold you the house yesterday, he didn't actually own it. He was running a scam.
Wow, so just a complete fraud.
Exactly. But then he says, funny story, my uncle died last night and left me that exact house in his will. So I own it now.
Oh, I see where this is going.
Right. He tells the judge that since he didn't own it yesterday, when you signed the papers, that contract is technically void. So he wants his house back and he is keeping your money.
That sounds like a bizarre hypothetical. I mean, that is the kind of thing a supervillain of real estate would try to pull off.
It really does. It feels like the ultimate loophole.
Yeah.
And I mean, your immediate gut reaction is that the legal system cannot possibly allow that guy to win.
Absolutely not.
He lied. She took your money. He can't just use his own fraud as a technicality to cancel the deal. But how does a judge actually stop him?
That is a big question.
But what is the specific mechanism, like the actual machinery of the law, that prevents the courtroom from descending into that kind of just absolute chaotic storytelling?
And, that is the core dilemma of the entire justice system. We tend to think of courts as these infallible truth-finding machines.
Like a medical x-ray or something.
Exactly like an x-ray that just scans a dispute and highlights the objective reality. But a court is really just a room full of people trying to reconstruct a past event.
Using some incredibly fragile tools.
Right. Fading memories and conflicting documents and totally self-serving narratives. Because the court wasn't there when the house was sold or when a crime was committed.
So they need ground rules. They need a framework for who gets to speak and who has to prove what.
And when a story is legally locked into place.
Which is exactly what we are digging into today. Welcome to the deep dive. We are pulling apart the mechanics of truth today.
And we are using some really fascinating source material for this.
We are looking at comprehensive university notes on evidence law from Osmania University, specifically looking at Unit 4 Ver, which covers the newly enacted Horatia Saksha Etiniam of 2023.
Also known as the BSA, which is just a massive paradigm shift.
It really is.
Yeah. The BSA is the sweeping new legislation that replaced the historic Indian Evidence Act of 1872. So we are talking about replacing a colonial-era framework with a modernized code.
Designed for contemporary society. But you know what is truly remarkable is that while the digital and forensic aspects of the law have evolved, the philosophical foundation remains the same.
The underlying logic of how we determine what is true.
Exactly. It remains rooted in some very deep and very tested concepts. Okay, let's unpack this. I want to start at the absolute foundation of that logic.
The ground floor.
Right. If I walk into a courtroom demanding justice, or demanding money, or demanding someone be put in jail, the court doesn't just say, okay, we will send our investigators out to see if you were right.
No, they absolutely do not.
The court just sits back and looks at me. Why is that?
Well, it is because of the adversarial nature of our legal system. The court is an impartial referee. It is not a detective agency.
They aren't going to do the homework for me.
Exactly. The foundational rule of evidence, which the new law preserves beautifully, boils down to a very simple maxim. He who asserts must prove.
So if I make the claim, I carry the weight.
Yes. The formal phrasing under Section 104 of the BSA is that whoever desires any court to give judgment as to any legal right or liability must prove that those facts exist.
We call this the burden of proof.
Right. If you want the machinery of the state to intervene in a private dispute or to deprive someone of their liberty, you have to do the heavy lifting. You have to show why that intervention is justified.
Let me test the mechanics of this with a quick scenario.
Okay, lay it on me.
Suppose I am at a coffee shop. I leave my laptop on the table to grab a napkin. I come back, and my laptop is smashed on the floor.
Oh, no.
And the guy at the next table is just sitting there sipping his latte. I drag him to small claims court and tell the judge, hey, this guy smashed my laptop.
Okay, so you made an assertion.
Right. But the guy says absolutely nothing. He just sits there in silence. The judge looks at both of us. What happens?
You lose.
even though he didn't deny it.
Even though he didn't deny it. Because the burden of proof rests entirely on the person who would fail if no evidence were presented by either side.
Ah, so the baseline is 0.
Exactly. You made the assertion, you brought 0 evidence, no witnesses, and no security footage, and no confession.
So his silence does not magically generate evidence for my side.
It does not. The scale started at 0, and since you added no weight to your side, you haven't met the burden.
Okay, that makes total sense for a smashed laptop. But when we elevate this to a criminal trial, say, a murder, the stakes are exponentially higher.
Oh, absolutely. The burden of proof isn't just about showing up with a receipt anymore.
Right, the phrase you always hear is beyond a reasonable doubt.
And that is a famously heavy burden, and deliberately so. You know, society has made a philosophical calculation that it is far worse to convict an innocent person than to let a guilty person go free.
So the prosecution's burden isn't just to show that the accused probably did it.
No, they have to eliminate any reasonable alternative explanation.
But the Osmania source documents point out something really interesting about this burden. It is not just a single static boulder that the prosecution carries on their back the entire trial.
It is actually broken down into 2 distinct layers.
Right, the legal burden and the evidentiary burden. And I'm trying to wrap my head around how those interact in a real trial.
It is one of the most dynamic aspects of a courtroom, so let's separate them. The legal burden is sometimes called the ultimate burden of persuasion, and this one never shifts.
It just sits there.
Yes. If the state charges you with robbery, the state holds the legal burden to prove you committed robbery from the moment the trial opens to the moment the judge decides. That is their ultimate destination.
So what is the evidentiary burden then?
Think of the evidentiary burden as the tactical, moment-to-moment obligation to produce evidence on a specific sub-issue.
So it is more granular.
Much more granular. Unlike the overarching legal burden, this evidentiary burden bounces back and forth between the 2 sides constantly.
Like a tennis match.
Yes, a very high-stakes tennis match. Let's say the prosecution serves the ball by putting a witness on the stand who says, "I saw the defendant rob the bank."
Okay, they hit the ball over the net.
Right. The prosecution has met their initial evidentiary burden for that specific moment. The ball is now in the defense's court.
So if the defense does nothing, the prosecution's evidence stands uncontradicted.
Exactly. So the defense has an evidentiary burden to hit the ball back. They cross-examine the witness and produce medical records showing the witness has terrible vision and wasn't wearing their prescription glasses that day.
Oh, a nice shot.
Very nice shot. They have shifted the evidentiary burden back to the prosecution. Now the prosecution has to produce new evidence.
Like maybe an optometrist who testifies that the witness's vision is actually fine at that specific distance.
Exactly. The ball bounces back and forth. But remember, through all this bouncing, the overarching legal burden never left the prosecution's shoulders.
They still have to prove the whole robbery beyond a reasonable doubt.
Exactly.
That makes the trial feel so much more alive.
Yeah.
It is a constant weighing scale reacting to every new piece of information. But there's another layer here that the law imposes, which feels incredibly rigid.
Are you talking about prerequisite proofs?
Yes, the sources talk about the burden of proving a fact just to make other evidence admissible. It is like a prerequisite requirement.
Yeah, under Section 107 of the BSA, this is a vital procedural safeguard. You cannot skip steps in the logic of the law.
So if you want to introduce a specific piece of evidence, but the rules say that evidence is only allowed under certain conditions, you carry the burden of proving those conditions exist first.
Exactly. The notes give a rather morbid example of this involving a dying declaration.
Right. It is the classic textbook example for a reason.
It is. So generally, courts do not allow hearsay. If you come to court and say, "My friend John told me he saw the defendant do it," the judge will stop you.
Because the judge wants John on the stand, under oath, subject to cross-examination.
Right. Hearsay is inherently unreliable. But a dying declaration is a major exception to that rule.
Because of the philosophical underpinning, right?
Yes. The idea is that a person is presumed to be telling the truth when they are on the brink of death. No one wants to meet their maker with a lie on their lips.
So if a victim uses their last breath to name their killer, the court wants to hear that. It is immensely powerful evidence.
But the prerequisite.
Right. You cannot just walk into the courtroom, wave a piece of paper, and say, "This is the dying declaration of Mr. Smith," where he names his attacker.
No, you must first definitively prove to the judge that Mr. Smith is in fact dead.
Because if he is not dead, the magical exception disappears.
Exactly. If Mr. Smith made that statement and then recovered and is currently having lunch at a diner downtown, It is not a dying declaration.
It is just hearsay again.
Right. The judge will tell you to go subpoena Mr. Smith and put him in the witness box. So the burden is entirely on you to establish the prerequisite fact before you unlock the ability to use the subsequent fact.
It's just like playing a video game where you have to find the silver key before the game even lets you see the silver door.
That is a great way to put it. You can't just bypass the sequence.
I'm imagining a situation where someone wants to submit a blurry photocopy of a contract because the original is lost.
Another perfect example of a prerequisite burden. The law operates on the best evidence rule. The court wants the original primary document.
So if you want to use secondary evidence like a photocopy or a digital scan,
Yeah.
you can't just say, oh, the original was heavy, so I left it at my office.
No, you carry the heavy burden of proving that the original was destroyed in a fire or hopelessly lost or in the possession of the opposing party who refuses to hand it over. Step 1 unlocks Step 2.
Okay, so up to this point, the logic is very linear. He who asserts must prove. The prosecution asserts guilt, and they carry the massive burden to prove it, beyond a reasonable doubt, step by agonizing step.
Yes.
But here's where I want to push back, because this is where the source material introduces a massive curveball. What happens when the defendant stands up and says, yes, the prosecution is right. I held the weapon. I struck the blow. I did the physical act. But I have a legally valid excuse.
This is the moment the legal landscape shifts violently. We're moving into the territory of general exceptions.
Right. And the university notes explicitly state that when an accused claims their case falls under a general exception, like self-defense or insanity or extreme provocation, the burden of proof violently shifts to the accused.
Yes, under Section 108 of the BSA. The statute commands that the burden of proving the existence of those exceptional circumstances is upon the person accused.
And it goes further with a very strict mandate. The text says the court shall presume the absence of such circumstances.
Yes, shall presume.
Shall presume. Meaning the court actively assumes the defendant is perfectly sane, wasn't provoked, and wasn't defending themselves unless the defendant can prove otherwise.
That is correct. The baseline assumption is full culpability.
I really struggle with this one.
Yeah.
I had to fight you on this point.
Go for it.
How does this not obliterate the presumption of innocence? I mean, the absolute cornerstone of a free society's legal system is innocent until proven guilty.
Right.
So if the state accuses me of murder and suddenly the judge tells me that I have to bring in psychiatrists to prove I was legally insane, isn't the judge effectively saying, prove you aren't a murderer?
I can see why you would phrase it that way.
It just feels like the state gets to outsource its own job to the defense.
I completely understand why it feels that way. It is the most common philosophical friction point for anyone studying criminal law. It feels like a betrayal of the golden rule. But if we connect this to the bigger picture, let's deconstruct what is actually happening.
Okay, let's deconstruct it.
To do that, we have to look closely at what constitutes a crime. A crime essentially has two components: the physical act, which we call the actus reus, and the guilty mind, or intent, the mens rea.
So the prosecution's overarching legal burden, the one we establish never shifts, is to prove both of those elements beyond a reasonable doubt.
Yes. They have to prove you swung the bat and that you intended to cause harm when you swung it.
Right.
If the prosecution fails to prove you swung the bat, you go home. The presumption of innocence protects you completely.
Oh, yeah, that makes sense.
But if the prosecution puts 5 witnesses on the stand who saw you swing the bat and produces a video of you swinging the bat and shows text where you said you were going to swing the bat, the state has met its burden.
They have proven the physical act and the intent.
Exactly. At that specific moment, the presumption of your innocence regarding the act has been defeated by evidence.
I am with you so far. The state proved the baseline crime.
Now, what does an affirmative defense, a general exception, actually do? When you stand up and claim self-defense or insanity, you are not saying I didn't do the act.
You are introducing a completely new contextual narrative.
Yes. You are saying, yes, I did the act, but I had a superseding justification.
Like saying I swung the bat because the other guy was pulling a knife on me.
Precisely. And who is asserting the existence of that knife? Who is asserting the feeling of imminent mortal terror?
Well, I am.
And we are back to the golden rule. He who assaults must prove. Because you are injecting a highly specific, personalized, factual scenario into the trial, the burden rightly falls on you to prove it.
So the state cannot be expected to proactively prove a negative.
Exactly. Imagine if the burden didn't shift. Imagine if the prosecution in every single trial had to prove beyond a reasonable doubt that you weren't insane,
Oh,
that
wow.
you weren't sleepwalking, and that you weren't coerced by a secret cartel threatening your family, and that you weren't provoked by a sudden insult.
It would be impossible.
The justice system would grind to an absolute halt. The state can only prove the observable crime. The internal exception must be proven by the person experiencing it.
So it is a pragmatic necessity. It actually reminds me of an athlete failing a drug test.
Oh, that is a good comparison.
Yeah, like the governing body proves the steroids were in your bloodstream. They have met their burden. If the athlete wants to claim, wait, I ate tainted meat at a restaurant in another country, the governing body doesn't have to fly around the world testing cows to prove the athlete didn't eat tainted meat.
Right, the athlete has to bring the receipts for the meat.
Exactly. The athlete asserts the exception, so they carry the burden.
That is an excellent modern analogy. The baseline assumption is that adults act with agency and sanity. The law presumes the absence of exceptional circumstances because exceptions are by definition rare.
So if you want the benefit of a rare exception, you carry the evidentiary burden to establish it.
Yes.
Okay, you have convinced me. The logic holds up. It balances the rights of the accused with the practical reality of running a functional justice system.
It does.
But this entire discussion hinges on the idea that evidence is actually available. Witnesses exist, bloodstreams can be tested, videos can be played.
Which brings us to the dark side of evidence law.
Right. What happens when the standard rules, this elegant, balanced ping-pong match of assertions and burdens, encounters a situation where the rules themselves are the reason justice fails?
You are talking about the notes on statutory presumptions, specifically regarding dowry deaths and domestic violence.
Yes. This is a profound and heavy pivot in the syllabus. Up to now, we've talked about how the law operates in an ideal, observable world.
But the legislature realized that certain types of horrific crimes do not happen in the observable world. They happen in the shadows.
They happen exclusively behind the closed doors of a matrimonial home. Let's contextualize this for a moment. We established that if the state asserts a husband murdered his wife, the state must prove it.
They need the murder weapon, the witnesses, the timeline.
But in cases of systemic domestic abuse and dowry-related violence, the victim is dead. There are no cameras in the kitchen.
No, and the only other people in the house are the husband's relatives who are highly motivated to lie and cover it up. The power dynamic is completely skewed.
Exactly. If the courts rigidly adhere to the standard he who asserts must prove rule in these specific scenarios, it would result in a parade of acquittals.
Abusers would systematically walk free simply because they successfully isolated their victims before killing them. The evidentiary burden was acting as a shield for perpetrators.
So the law had to intervene. The law had to essentially break its own rules to protect a vulnerable class of people. Here is where it gets really interesting.
It is a form of social activism codified into the rules of evidence. We see this in Section 118 of the new BSA, which carries forward the critical intent of the old Section 113B of the IEA regarding the presumption of dowry death.
Let's unpack the mechanics of this presumption. A dowry death, legally speaking, is when a woman dies an unnatural death and is shown that she was subjected to cruelty or harassment by her husband or his relatives in connection with the demand for dowry.
Right.
The university notes lay out 5 very strict foundational conditions that the prosecution must establish before this legal magic trick activates. Let's go through them.
The foundation must be solid. First, the deceased must be a woman. Second, the death must have occurred within 7 years of her marriage.
Let's pause on that 7-year timeline. Why 7 years? Why not 5 or 10? It seems oddly specific.
It is specific, and it's based on sociological realities in India. The legislature recognized that the first several years of a marriage are a period of intense transition and vulnerability for a newlywed woman in many traditional domestic structures.
Right, she is entering a new household.
Yes, adjusting to new power dynamics. And this is the window where relentless pressure for dowry, property, or cash is most likely to escalate into fatal violence.
Beyond 7 years, the assumption is that the familial dynamics have stabilized, for better or worse.
Exactly. And the specific causal link to dowry becomes legally harder to automatically presume.
That makes a chilling kind of sense. It targets the highest risk window. Okay, the third condition, the death must be unnatural. Burns, bodily injury, poisoning, hanging. Something other than normal circumstances.
Right.
Fourth, it must be shown that she was subjected to cruelty or harassment by her husband or his relatives. And fifth, that cruelty must be connected to a demand for dowry occurring soon before her death.
Now, if the prosecution can prove those 5 things, and to be clear, they still carry the burden to bring evidence of the harassment.
Right, through letters to her parents or witness testimony from neighbors who heard shouting.
Yes, or medical records of previous injuries. They can't just assert the harassment, they have to prove the harassment.
Right. But if they prove those 5 foundational facts, look at the language of the statute. It does not say the court may consider if he killed her.
No, it says the court shall presume that such person had caused the dowry death.
Shall presume. There is that phrase again. It is a mandate.
It is an absolute legal mandate. The court is stripped of its discretion. The judge cannot say, well, the prosecution proved he beat her for dowry on Tuesday and she died of unnatural burns on Thursday. But since no one actually saw him strike the match, I have to acquit due to reasonable doubt.
The law takes that option away.
Completely. The law aggressively steps in and says, we are creating a legal fiction. We presume he struck the match. The gap in the evidence is filled by the force of the statute.
That is an immense amount of state power. So what happens to the husband? Does the gavel just drop and he is sent to prison?
No, because it is a rebuttable presumption. What has happened is that the burden of proof has been violently, forcefully shifted onto the accused.
So the husband now carries the evidentiary burden to step into the box and prove with actual evidence that he did not cause the death.
Exactly.
How does someone even do that?
He has to provide an alternative, verifiable narrative. He must prove it was a tragic kitchen accident while he was at work, supported by alibi evidence and forensic fire analysis. Or he must prove it was a completely independent act.
But the crucial point is that his silence is no longer a defense.
Right. If he just sits there and says nothing, the presumption becomes the reality and he is convicted.
The sources cite a couple of Supreme Court cases that really highlight the nuance here. State of Punjab v. Iqbal Singh reinforces the strict application of this. Once the foundation of soon before harassment is laid, the presumption locks down hard.
Yes.
But then Kansraj v. State of Punjab offers a slight warning. It clarifies that while this presumption heavily arms the prosecution, it doesn't give them a free pass on the initial legwork.
They can't just show up, prove a woman died, whisper the word dowry, and expect the judge to do the rest.
Exactly. The presumption is a bridge over a river, but the prosecution still has to build the road leading up to the bridge.
The notes make a fascinating contrast here, too, comparing the dowry death presumption to another related statute.
Right. The presumption as to the abetment of suicide by a married woman.
Yes. This distinction is critical for understanding how carefully the legislature calibrates these rules. If a married woman commits suicide within that same vulnerable 7-year window, and it is shown she was subjected to cruelty, the statute under Section 113A of the old IEA says the court may presume that the suicide was abetted by the husband.
May presume, not shall.
Precisely. In the dowry death scenario, the presumption is mandatory. The law forces the conclusion because unnatural death coupled with dowry demands strongly indicates homicide.
But suicide is psychologically complex.
Extremely. A person might face terrible cruelty at home but ultimately take their life due to unrelated severe clinical depression, outside financial ruin, or other deeply personal crises.
I may presume gives the judge the flexibility to look at the whole picture.
Yes, it is discretionary. If the woman left a detailed suicide note explicitly blaming her boss at work for destroying her career, the judge may choose not to invoke the presumption against the cruel husband regarding the specific act of abetting the suicide.
Even if he is guilty of domestic violence under other statutes.
Exactly. The may allows the court to avoid a mathematically rigid injustice.
I find this entire area of law incredibly moving. You know, when you study law from a distance, it looks like cold math. Input the facts, output the justice.
Yeah, it can feel very detached.
But looking at these presumptions, you see the messy, tragic reality of human behavior. And you see a legal system actively trying to correct its own blind spots. It recognizes that abusers weaponize the standard burden of proof, so the law reaches out and rips that weapon away.
It is a profound realization. The rules of evidence are not morally neutral algorithms. They are social policy in action.
They adapt to ensure that a lack of direct evidence doesn't become a permanent license for systemic brutality.
Beautifully said.
All right, I want to take a breath and shift gears entirely. We have spent this entire time navigating the dark waters of criminal law,
Examining how the court infers truth when life and liberty are on the line.
Now I want to move into the realm of civil fairness. We've talked about how the court figures out what happened, but what happens when someone deliberately tries to change their story halfway through the game?
We are entering the territory of Estoppel. This is covered in Chapter 8, Section 121 of the new BSA.
Estoppel. It is such a strange, antique-sounding word, but conceptually I absolutely love it. It feels less like a complex legal doctrine and more like playground fairness.
It really does.
It is the legal equivalent of no takebacks.
That is essentially what it is.
Yes.
Section 121 defines it formally. When one person has, by his declaration, act, or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed to deny the truth of that thing.
You made me believe this. I acted on it. You cannot now claim you were lying.
Exactly.
It brings us right back to the scenario I opened the show with. The guy who sold me the house he didn't own, then inherited it the next day and tried to cancel the contract because of his initial lie.
And this is exactly where the doctrine of Estoppels slams the door shut on him.
Walk me through the exact mechanics of how the judge applies Estoppel to that scammer.
So the court will look at the seller and say, you intentionally represented that you were the rightful owner of this property. The buyer believed your representation. And most importantly, the buyer altered his position to his detriment by giving you his life savings based on that belief.
Because I wired him all my money.
Right. So the judge says you are now legally estopped from denying the truth of your original representation.
He is bound by his own lie.
Yes. The underlying philosophy here is equity and good conscience. The law refuses to allow someone to profit from their own fraud. You cannot approbate and reprobate.
What does that mean?
It means you cannot accept the benefit of a transaction and then reject its burden. So for the purpose of this specific legal dispute, the court will treat his original lie as the absolute legal truth.
The transfer is validated the moment he actually acquires the property.
Exactly.
So the court is essentially saying, we don't actually care about the objective timeline of when the deed transferred. We care about fairness. You made your bed, now lie in it.
Exactly right. But the critical element to remember here, the hinge upon which Estoppel swings, is detriment.
Detriment meaning harm.
Yes. The person claiming the protection of Estoppel must prove they suffered a detriment by relying on the lie. If the scammer told you he owned the house and you knew he was lying but you signed a fake contract just as a prank without paying him any money, you cannot later claim Estoppel to force him to give you the house when he inherits it.
Because I didn't suffer any detriment. I didn't lose anything based on his lie.
Precisely. Estoppel is a shield to protect the innocent from harm, not a sword, to enforce casual promises where no damage occurred.
Now, the syllabus goes into incredible detail on this, breaking down the different kinds of estoppel. It is not just a one-size-fits-all rule. It is an entire spectrum of accountability.
Let's explore these variations because they apply to very different parts of life.
Okay, what is the first one?
The first is what we just discussed. Equitable estoppel or estoppel by conduct. It arises from words, actions, or deliberate deception between private parties.
But then we get to promissory estoppel, and this is where things get massive. We aren't just talking about private citizens anymore.
Promissory estoppel is a fascinating evolution of the doctrine. Traditionally, estoppel only applied to lies about existing facts like I currently own this house.
It did not apply to future promises.
Right, but promissory estoppel bridges that gap. If a party makes a clear, unequivocal promise about the future intending the other party to act on it, and they do act on it to their detriment, the promisor cannot go back on their word.
Even if there was no formal signed contract.
Exactly.
And the notes highlight a landmark case here, Union of India v. Indo-Afghan agencies. Why is this case so important?
Because it applied promissory estoppel against the government itself.
Yeah.
In this case, the government announced an export concession policy. They said, if you export goods, we will give you a certain allowance.
So businesses read this, trusted their government, altered their business models, and exported goods to their detriment.
And then the government tried to pull the rug out. They essentially said, we changed our minds. That was just a policy statement, not a binding contract.
And what did the court do?
The Supreme Court stepped in and said, no. The government is not immune to equity. You made a promise. Citizens relied on it. You are stopped from arbitrarily withdrawing it.
That is incredible. It holds the sovereign state accountable to basic playground fairness. It prevents the government from acting like a tyrant who can change the rules after the game has started.
It is a massive check on administrative power. But it has limits, which we will get to. Let's look at another highly specific variation, estoppel against tenants. This is codified in Section 122 of the new BSA.
Let me guess. If I rent an apartment, I can't suddenly claim the landlord doesn't own it.
Exactly right. A tenant during the continuance of their tenancy is not permitted to deny that their landlord had a legitimate title to the property at the beginning of the tenancy.
Let's explore the why behind this. Suppose I am renting a place. I have lived there for 3 years.
Hmm.
I pay my rent every month. One day, I am bored on the internet. I do a deep dive into public property records, and I discover a weird clerical error from 40 years ago. It turns out my landlord's grandfather didn't file a deed correctly. So technically, my landlord doesn't hold the perfect legal title to the building.
Oh, I see.
Can I just stop paying rent and say you are not the real owner? I am living here for free now?
The law says absolutely not. By signing the lease, taking the keys, and enjoying the shelter of the apartment, you have legally accepted them as your landlord. You have derived a massive benefit from their representation of ownership.
Right, I got a place to live.
So you are stopped from weaponizing a title dispute against them while you sit comfortably in their property.
It prevents chaos.
Complete chaos.
Yeah.
If tenants could arbitrarily challenge titles to avoid paying rent, the entire rental market would collapse into endless litigation. Now, if the tenant genuinely wants to challenge the title, law says fine, but you must first vacate the premises and surrender possession back to the landlord.
You cannot have your cake and eat it too.
Exactly.
That makes perfect sense. It stabilizes the whole system. Now, there are 2 more variations mentioned: estoppel by negligence and estoppel by acquiescence. These feel different because they don't involve an active lie.
They involve silence or just being incredibly careless.
Yeah. These are subtle but incredibly important. You don't have to look someone in the eye and lie to trigger estoppel. Let's take negligence. Suppose you run a business and you casually leave a stack of pre-signed blank company checks sitting on the front reception desk.
That is wildly irresponsible.
It really is. Now, suppose a rogue employee steals one, fills in a massive amount, and uses it to buy a car from an innocent third-party dealership.
Okay.
When the dealership tries to cash the check, can you stop payment and claim I never authorized that purchase, the employee stole it?
I feel like the dealership should win this one. You left the signed checks out.
And you would be right. You might be stopped from denying the validity of the check because your extreme negligence created the environment that misled the innocent dealership. You enabled the fraud.
And what about acquiescence? That means silently agreeing, right?
Yes. Silence can be a representation. Imagine you own a large plot of land. You see your neighbor, who mistakenly believes a portion of your land is theirs, start pouring a concrete foundation to build a house on your property.
Wow.
You know it is your land, but you say nothing. You sit on your porch, drink iced tea, and watch them spend $50,000 building a house over 6 months.
Oh, this is devious. You are waiting for them to finish the house so you can claim it as an improvement on your land.
Exactly. When the house is finished, you walk over with the property deed and say, "Thanks for the free house, get off my lawn."
And the doctrine of estoppel by acquiescence stops you cold.
Right. The court will say that your deliberate silence while watching someone act to their detriment under a mistaken belief binds you. You acquiesced to their action.
So you may be forced to let them keep the land or compensate them fully.
This is all so fascinating. It really paints a picture of a legal system obsessed with enforcing good faith. But listening to all this power, my instinct is to ask, is estoppel a magic spell?
What do you mean?
Can I just yell estoppel in the middle of any argument to freeze someone in their tracks? There have to be exceptions.
There are rigorous limitations. Estoppel is a tool of equity, not a weapon of mass destruction. Let's go through the major exceptions where estoppel absolutely does not apply.
Exception number 1.
Estoppel does not apply against questions of law. You can be estopped from denying a fact, like I own this house, but you cannot be estopped from arguing the correct interpretation of the law.
Give me an example of that.
Suppose I am a police officer and I mistakenly tell you that the speed limit on a particular highway is 100 miles per hour.
Okay.
You rely on my statement, you drive 100 miles per hour, and a different officer pulls you over and writes you a massive ticket because the law actually says the limit is 65.
Oh, man.
You go to court and argue the first officer represented the limit was 100. I acted to my detriment. The state is estopped from ticketing me.
Does it work?
It fails completely. The law is the law objectively written in the statute books. No individual's misrepresentation can alter a legislative statute.
Right. You can't estop your way out of a crime. What is the second exception?
It goes back to our discussion about the government. While promissory estoppel can apply to administrative policies or contracts, it generally does not apply against the sovereign legislative acts of the government.
So you cannot stop the legislature from passing a new tax law, even if a politician promised on the campaign trail that they wouldn't raise taxes.
Exactly. Otherwise, democracy would be paralyzed by every speech a politician ever gave.
That makes perfect sense. Now, the third exception is the one that completely broke my brain when I read the notes. Estoppel does not apply against a minor.
Ah, the classic law school debate.
Let's set the stage for this. You have a 17-year-old kid. He is a smooth talker. He gets a highly realistic fake ID that says he is 22.
Okay, a tale as old as time.
He walks into a bank, sits down with a loan officer, confidently lies about his age, presents the fake ID, and signs a legally binding contract to borrow $40,000 to start a business.
That's bold.
The bank gives him the money. He blows the money on a terrible crypto investment and loses it all.
Typical.
The bank sues him to get the money back. The kid stands up in court and says, "Your Honor, I am actually only 17. Under the law, a minor lacks the capacity to form a contract.
Right.
Therefore, the contract is void, ab initio void from the very beginning. I don't legally owe them anything."
And the bank's lawyers immediately scream Estoppel. He intentionally lied about his age. He presented a fake ID. He caused us to act to our detriment by giving him the loan. He is estopped from now claiming he is a minor.
Exactly. The kid committed blatant premeditated fraud. It is the textbook definition of estoppel. He should lose.
But he wins. The court will side with the lying teenager. Estoppel does not apply against a minor.
I need you to explain the philosophy of this to me because it feels incredibly unjust to the bank.
It is a clash of two massive legal titans, equity versus statute. Estoppel is a principle of equity fairness, but the law declaring that minors cannot be bound by contracts is a hard statutory rule.
Why is it so hard?
It is a paternalistic policy designed by society to categorically protect children from their own foolishness, from predatory lenders, and from lifelong financial ruin before their brains are fully developed.
But he wasn't innocent. He lied.
The law assumes that minors lack the maturity to even understand the consequences of their lies. If the court allowed the bank to use Estoppel here, what would happen?
I guess a minor could just lie their way into debt.
Exactly. It would mean that a minor could accidentally or intentionally contract themselves into binding, crushing debt simply by lying about their age. It would create a backdoor that completely destroys the protective shield the statute intended to build around youth.
So the law decides that the overarching societal need to protect all minors is more important than achieving perfect fairness in this one specific transaction with the bank.
Precisely. As the legal maxim goes, there can be no estoppel against a statute. The protective policy overrides the equitable grievance. The bank should have done better due diligence.
Wow. That is a bitter pill for the bank. But I understand the macro logic. It is about protecting the vulnerable class, even when an individual in that class acts in bad faith. Okay. What is the final exception to estoppel?
The final exception is the most logical one. Estoppel does not apply when both parties already know the actual truth.
Right. We touched on this earlier.
Yes. The entire doctrine is predicated on one party being genuinely misled. If a guy standing in Times Square offers to sell you the Brooklyn Bridge for $50, and you know perfectly well he doesn't own it, but you give him $50 anyway just for the laughs, you cannot later sue him and claim estoppel.
Because you are not deceived.
Exactly. You can't claim you relied on a lie if you knew it was a lie. Estoppel is a shield for the innocent, not a weapon for the complicit. The truth must be hidden from the person claiming the estoppel.
All right, this brings us to the final massive concept in our exploration of the mechanics of truth. We just spent all this time talking about how the law stops people, scammers, landlords, the government from endlessly changing their stories. But it turns out the legal system itself has a mechanism to stop the endless storytelling of the courts.
Yes. If ordinary estoppel governs the behavior of the individuals, we are now moving to the doctrine that governs the finality of the court's own processes. We are talking about res judicata.
Res judicata. It sounds like an ancient spell.
It is Latin for a matter judged, and it is perhaps the most crucial doctrine for the survival of a functional society. It is codified in sections 54 through 56 of the new BSA.
What is the core principle?
The core principle is absolute finality. A matter that has been finally decided by a competent court cannot be reopened, retried, or relitigated between the same parties. Once the gavel falls and all appeals are exhausted, the issue is dead.
Let's play this out. Suppose I get into a bitter feud with my neighbor. I am absolutely convinced he snuck onto my property in the middle of the night and cut down my prize-winning apple tree.
Okay, so you sue him for damages.
Right. We go to court. We present witnesses. We present soil samples. We argue for 3 days. Finally, the judge looks at everything and says the plaintiff has not met the burden of proof. I rule in favor of the neighbor. He didn't cut down the tree.
You lose.
I lose. But I am furious. I am convinced the judge was biased or didn't understand my soil samples. Without res judicata, what would stop me from just waking up the next morning, driving to a different courthouse across town, paying the filing fee, and launching the exact same lawsuit against the exact same neighbor all over again, hoping to get a judge who likes me better?
Nothing would stop you. And that is the nightmare scenario. If there was no res judicata, the loser of a lawsuit could simply harass the winner until the end of time.
They could just keep suing them forever.
The wealthy could completely bankrupt the poor by forcing them to pay lawyers to defend the exact same claim year after year.
It would be a legal zombie apocalypse. No dispute would ever actually die.
And society would collapse under the weight of unresolved grievances. Res judicata is the ultimate legal game over screen. It exists because the system recognizes a profound truth.
Which,
It is in the interest of the state that there should be an end to litigation. A justice system that cannot provide finality is not providing justice at all. It is just providing an arena for endless feuding.
it prevents contradictory judgments, too. If I sued my neighbor 5 times, I might eventually win one, just by sheer statistical luck. Then we'd have 4 judgments saying he didn't do it, and 1 saying he did. How would anyone know what the legal truth is?
Exactly. Res judicata locks in the legal truth permanently to maintain the integrity of the courts. But the source notes draw a really fascinating and highly technical distinction here about the scope of that finality.
Right, they differentiate between judgments in rem and judgments in personam. Let's break those down. What is a judgment in rem?
In rem translates roughly to against a thing, but legally it refers to a judgment that determines the legal status of a person or a thing. And the incredible power of a judgment in rem, which is covered under Section 54 of the BSA, is that it is conclusive against the entire world.
Against the entire world, not just the people in the courtroom.
Correct. The most common examples are judgments granting a divorce, determining legal heirship like probate, or declaring someone legally bankrupt or insolvent.
Let's use the divorce example. If a family court judge signs the final decree granting a divorce between a husband and wife, that is a judgment in rem.
Yes. The court has fundamentally altered their legal status. They are no longer a married unit, they are 2 single individuals. And that judgment binds everyone on the planet to that new reality.
So the tax authorities must treat them as single. Their employers must treat them as single.
Yes, if one of them goes to Las Vegas the next day and wants to marry someone new, the state of Nevada is bound by that judgment.
So if a crazy ex-mother-in-law tries to argue a year later, no, in the eyes of God, they're still married, I won't acknowledge this, the divorced person can just hold up the judgment in rem and say, it doesn't matter what you think.
Right. The court decided this status for everyone. It provides absolute universal finality regarding status, which allows people to move on and society to function seamlessly.
Okay, so that is in rem. What is a judgment in personam?
A judgment in personam, or a judgment not in rem, addressed in Section 55, is a decision regarding the specific rights and obligations between the specific parties in a specific dispute.
So your apple tree lawsuit is the perfect example.
Yes. The judge ruling that my neighbor didn't cut down my tree, that judgment is in personam. It is binding and final between you and your neighbor.
So res judicata prevents me from ever suing him over that tree again.
And this is the key difference. It is completely irrelevant to the rest of the world.
Meaning what?
Meaning, if a completely different neighbor down the street decides to sue your tree-cutting neighbor for allegedly stealing a lawnmower, that new plaintiff cannot bring your court ruling into their trial.
They can't say, look, Judge, this guy was sued for cutting down a tree last year, so he's obviously a bad guy who steals lawnmowers.
Exactly, because your lawsuit was just between you and him. It didn't establish a universal status for him.
So judgments in personam lock the door on a specific dispute between specific parties. Judgments in rem lock the door on a person's legal status for the entire world.
Both mechanisms exist to build a foundation of settled, unquestionable facts so that society can actually move forward.
Wow, we've covered an immense amount of ground today. We've looked at the very bedrock of how we determine what is true when everything is contested.
We started with the sheer physical weight of the burden of proof.
We explored the philosophical battleground of making the accused prove their own exceptions. We looked at how the law engineers statutory presumptions, bending its own rules to protect victims of domestic violence and dowry deaths from the silence of closed rooms.
And we examined the equitable fairness of Estoppels, ensuring people cannot profit from their own deceit or negligence.
And finally, we ended on the immovable wall of res judicata, the doctrine that forces an end to the storytelling. When you step back and look at all of this, the new Haratia Saksha Adhinyam, the shifting burdens, the exceptions, the Estoppels, It paints a picture of a legal system that is deeply, almost painfully self-aware.
It really does. It knows that it isn't an infallible X-ray machine. It knows that absolute perfect truth is often buried, burned, or forgotten.
It is a system built on pragmatism. It is a living, breathing apparatus that constantly calibrates itself. It shifts burdens to who can bear them best. It creates fictions to protect the weak.
It locks down judgments not because it is perfectly sure, but because it knows we need to survive as a community.
Which brings me to a final thought I want to leave on the table today. We've spent an hour looking at the machinery of legal truth. We've seen that truth in a courtroom is heavily dependent on who happens to carry the burden to prove it. We've seen that the law will literally mandate that a judge presume a fact exists without direct evidence to serve a broader social good. And we've seen that a judgment becomes locked in by res judicata, becoming the unassailable legal reality forever, regardless of whether a brand new piece of evidence might surface 10 years later.
So I think we have to ask ourselves, does the courtroom actually care about uncovering the absolute objective historical truth of what happened in the past?
Or is the system with all its burdens, presumptions, and estoppels simply trying to construct the most procedurally fair and final version of it?
That is the ultimate tension. Are we seeking perfect truth, or are we settling for functional peace?
That is something that changes the way you look at every headline, every trial, and every argument. I thank you for diving into the mechanics of the law with us today. Keep questioning the rules of the game, and we will see you next time on The Deep Dive.